Judge Gamble, we welcome you here this morning, and we're like to hear your opening statement.
Good morning.
Good morning.
Hi, Judge.
I'm glad to see all of you. For those of you who do not know me, I would like to introduce myself. Thank you, David. I am Art Gamble. I am the Chief Judge of the 5th Judicial District of Iowa. The 5th District includes Polk County and the 15 south central Iowa counties in our state. Includes the most metropolitan court, the largest court in the state, as well as several of our most rural courthouses. I am an Iowan, born and raised here in Des Moines. I attended Roosevelt High School and the University of Iowa, where I graduated with a law degree in 1978. I'm married to my lovely wife, Nancy. We have 4 children, 2 of whom are married. And as far as experience goes, raising those 4 kids, I think is the greatest experience anyone could have. Upon graduation from law school, came back to Des Moines, where I practiced law in a law firm with my father and my brother. It was a great honor to be able to do that and a great experience for me. It was a type of law firm that provided a young lawyer a great deal of experience in a very short period of time. And fortunately, I was able to pursue my dream of becoming a judge perhaps earlier or sooner than I anticipated. But I was appointed to the district court bench in 1983 by Governor Terry Branstad. In the first several years of my judicial career, I served in our South Central Iowa counties of judicial election districts 5A and 5B in southern Iowa, where I attended court service days and got a great deal of tremendous experience as a judge for the first 5 or 6 years of my career in those rural courts. I got to know the communities in our district, the courthouses of our district and all of the people who worked there, the clerks, and of course the people who come to our courts every day for the resolution of their disputes. In about 1988, I was transferred into Polk County, and where I have served ever since, primarily on what we call in Polk County a general trial assignment, which is an assignment of civil litigation, including administrative appeals, workers' compensation appeals, utility rate appeals, and so forth, post-conviction relief proceedings, family law. Also, the Polk County assignment includes a rotation into what we call the specialty benches of family law for 1 year at a time and criminal law for 1 year at a time. And in those rotations, a judge has exposure to a high volume of cases in that particular discipline. I just finished a year hearing felony criminal trials on the Polk County criminal bench. I've always had an interest in judicial administration, and so in the 90s, Chief Judge Moore asked me to be his assistant chief judge. And I learned a lot about judicial administration. I learned about crisis management. I handled the floods of '93 and dealt with evacuating the Polk County Courthouse and the Polk County Jail, establishing an appearance court for what we anticipated might be a crime wave, which, true to form in our community, did not occur. That experience helped me, I think, to be appointed Chief Judge of the 5th District in 1995. and I've served as the chief judge for the last 15 years. I have managed our district initially through a period of growth, with the addition of new judges and staff, and though through the last decade, a period of contraction and budget cuts, furloughs, layoffs, and change. So I believe that my background and my training and my experience provides me with a unique combination of qualifications at the right time to appear before you today. So I would appreciate the opportunity to answer any questions that you might have.
Thank you, Judge. Let's start with Mr. Brody.
Good morning, Judge.
Good morning, Mr.
Thank
Brody.
you for being here. As a constituent of mine, I really want to welcome you for being here.
Thank you, sir.
It's been shared with the commission in one of the many letters that we've received that elevating a judge from the district court to the Supreme Court does not necessarily guarantee a successful Supreme Court justice. I presume you disagree with that argument, and so I was wondering why that presumption is correct, that you might disagree with that argument that's been shared with us.
Well, I can only answer that from my own perspective based upon my own experience. And I think that based upon the experience that I possess, the experience of a district court judge on the appellate court would be a value to be added to the court, and not something that would detract from the ability of the justice. And I say that because as a district court judge, you have the opportunity to hear numerous cases in various fields of law, resolving the disputes that the parties bring to you in civil cases, and presiding over the prosecution of criminal cases. And so the experience that you have reading appellate decisions and applying the law that the appellate courts give to the district court, I think is valuable for a justice when they come to the appellate court and sit in the conference and discuss the implications that a decision may have on the trial court bench. So I think it's something that is an added qualification. So at least with respect to my own constellation of qualifications, I would disagree with that statement.
Thank you.
Mr. Holm?
Thank you, Justice Wiggins. Good morning, Judge Gamble. One question that I would like you to maybe address for us is how you perceive the transition from being a sole decision maker in your role as a district court judge into the collaborative decision making of the Supreme Court.
I think that is the most exciting part of this opportunity. I have for 27 years had the honor and the pleasure of hearing cases for the citizens of our state at the district court level and calling the balls and strikes the best way that I know how. But I think that at the appellate level, you have the opportunity for various justices coming from various backgrounds with different levels of and constellations of experience to contribute their knowledge about the law and about the facts of the case to the conference so that at the court of last resort, the highest court of our state, we have every opportunity to get it right. And so where I enjoy my independence, I very much value it. I think I get it right most of the time, although occasionally the Supreme Court may disagree. I think that participating in the collaborative or collegial decision-making process would be a great opportunity. And I really would look forward to doing that.
Mrs. Redenbaugh?
Thank you, Justice. Judge, I think you're aware that we have over a dozen judges, district judges, that have applied for this position. And as a layperson, they without experience in the courtroom, they all kind of start looking the same. Could you help me with the criteria for bringing the best of those district court judges to that final 9?
I believe that the primary quality that you should be looking for in a district court judge is a demonstration over the years of the judge's career of judicial temperament, work ethic, experience in various kinds of cases, writing ability, the ability to analyze a legal question, and to write a decision that the parties can accept even though they may disagree. So I think that's the primary quality that you should be looking for.
Thank you.
Ms. Skogerson?
I'm sorry to you over there. I'll try to make it brief. Judge Gamble.
They could wait. They've had their turn this morning.
Thank you for being here today and for applying for this position. You have been somewhat in the unique position of getting a mediation program going in the 5th Judicial District. And as I understand things, about 10 years ago, you were maybe not in favor of mediation, but have somewhat been converted to a believer at this point, and I think have seen the benefits of that. I was wondering, particularly I'm talking, of course, in domestic relations cases, I was wondering how you feel the Supreme Court might have a hand in dealing with whether mediation should become mandatory throughout the state in family law cases, and also whether you think that might help to improve our budget situation, and finally, how you think that your handling of implementing mediation, I guess coming from a non-believer to a believer, that it's a successful process, how that might assist you in that line of that ability to change your mind about something might serve you well on the Supreme Court. So there you go, my 3-parter.
All right, well, let me use this question as an opportunity to communicate to all of you the way that I go about making an administrative decision as the chief judge. I may come into a particular problem with a particular point of view, but I tend to seek the input of other stakeholders in our system who have various points of view. So when Judge Jack Levine and Judge Eliza Overham approached me about instituting a family law mediation program in Polk County, I think I exercised the first quality of a good leader, and that is I did not say no. What I did was instead appointed a task force or a committee, project team, if you will, of the various stakeholders of the family law courts in Polk County, the attorneys that practice there, and let them develop a program that they thought might work in our courthouse. Each courthouse has a different local legal culture, and they didn't entirely break new ground because this had been tried successfully in the 6th Judicial District in Cedar Rapids. Judge Levine led the committee, and the committee came up with the protocols that we have now in Polk County. And I became convinced to say, yeah, let's try that. Let's see if that works. Let's see if that helps, because I became convinced that people who are going through our process in family law cases want to have a greater hand in resolving their own dispute. But because of the dynamics that they're going through in divorce cases in particular, they don't always have the tools to be able to do that. So mediation was a way to encourage that process. And over the course of the years, we have found a great level of satisfaction among the litigants in particular with regard to family law mediation. The lawyers, even the skeptics, and the judges who have participated now, today, would not want to do family law cases in Polk County without it. And it does save a great deal of resources and trial days. One thing in particular that it does, it may settle cases that are going to settle anyway. Typically our cases do settle, some of them don't. But a lot of times they would settle on the courthouse steps, so to speak, or with a little pre-judge nudge about what do you think about this issue, Judge? What would you do if you had these facts, Judge? Then they go out in the hall and settle the case. I think that is not a good way to resolve the disputes. This way, the parties have the opportunity through mediation, pre-trial, to hammer out their own settlement. And if they don't, we know the case is going to go to trial. And we don't do any of the pre-judge negotiation type of thing on the courthouse steps. I think it's been a very valuable program. So in the past year or so, with the leadership of the Chief Justice and the Judicial Council, we've decided in the 5th District to expand the mediation program into both our 5A and 5B communities. And so in doing that, again, appointed another project team because the legal culture in 5B in southern Iowa is different than it is in Polk County. And we wanted to get input from everybody who might be involved in that. We met with the lawyers. If I remember correctly, Amy, I think you attended that meeting. Got input from the attorneys and came up with a program that not only, I think, expands the program into the rural courts, but also improves upon the program that we have in Polk County. And we're piloting that program now in Dallas County, Warren County, and Clark counties. And I anticipate a successful transition into all of our counties very soon. What the Supreme Court can do is what they're doing now. Let us try some things, see what works, see what doesn't work, and then encourage the expansion of best practices throughout the state.
Mr. Cook?
Your Honor, you've been a judge almost 30 years, 15 of which chief judge of the busiest courthouse in the state of Iowa. Frankly, from my perspective, I think you've probably seen it all. I don't want to ask you about those experiences. What I would like to ask you about is a couple of years ago, you worked with a group that I was involved with to try to build a courthouse, a new courthouse in Polk County. It was unsuccessful. Tell us what you learned from that experience and what value you could bring to the administrative aspects, the budget aspects, and dealing with the legislature if you were on the court.
Well, thank you for bringing up that unsuccessful effort. What did I learn from that? First of all, you know, we did all of the things that I just discussed with Amy. We established a multidisciplinary committee. We called it the Building for Justice Committee. Guy Cook and Eric Turner, former presidents of the Polk County Bar Association, led this effort along with the courts. We sought the input of the National Center for State Courts on courthouse design and construction. We met numerous times, and we're still meeting with the Polk County Board of Supervisors and their administrative staff to come up with a plan that we thought would satisfy the long-term needs of the Polk County Court out 15, 20, 30 years. We thought at that time that the best solution, with all of the input that we received from all of our stakeholders, was to build a new courthouse under one roof on a lot just south of the Polk County Courthouse, move the entire court system into one building, renovate the Polk County Courthouse, and reoccupy the historic courthouse with some of our courts. And along with that dream came a price tag. The price tag was, Guy, you could correct me if I'm wrong, but about $125 million, something like that. And it had to stand for referendum and approval by the taxpayers. What we learned in hearing from those who opposed this initiative was that the taxpayers were concerned about the cost and the increase that they might see in their property taxes. The opponents also questioned the validity of our assumption that the court system should be under one roof. So when we went to referendum, I think we did a really good job on a shoestring budget of doing a grassroots effort to convince Polk County taxpayers and Polk County voters that a new courthouse was needed because of the overcrowding in our courthouse, the security concerns and the safety concerns we have there. But the voters decided not to pass the referendum. What I take from that is that you, as a court, as a judge, have to remember that you work for the people and that the people want a voice in their court system. And sometimes their ideas are very, very good. So what we're doing here now in response is taking some of the ideas that were suggested to us by the opposition to our courthouse referendum and evaluating and looking at whether the court could expand into a number of buildings, including the old jail across the street and some other buildings down around the courthouse in a courthouse campus type atmosphere that will go in phases over time to achieve hopefully the same goal, maybe for less money than what we proposed. So the lesson is that when the voters speak, the courts need to respond, reevaluate with regard to the administration of justice, reevaluate where we have been, try to formulate with input from the citizens of our state and all of our stakeholders where we go from here. Justice Wiggins, I see my light is red.
That's okay, we have plenty of time. Any questions on the right side? Mr. Pace. We don't have plenty of time, but.
Thank you. I'll try to be brief. Hi, Judge. I recall going to a bench bar conference a number of years ago, and I can't tell you how many, but I do recall that there were Supreme Court justices there, district court judges, lawyers, and other folks. And one of the things that was done there, it was at the Amana colonies, one of the things that was done there was to talk about the public's perception of the court system. And as I recall, you were offered up as an example of an interaction with the public. And there was even a woman there that had been a litigant and was talking about the way you had handled the trial. It was quite difficult, as I recall, a number of things. I only asked this in the context of judicial temperament. You mentioned judicial temperament, and there were a lot of comments, very positive ones in that presentation by her and others about your temperament. But I'd like you to address that for us, your temperament.
The case was Chanin versus UPS. It was a sexual harassment case brought against UPS by Linda Chanin, now Linda Murphy, who is an attorney here in Polk County. And you know, you're talking about a person who at that time felt that she had been terribly wronged by a large company. She was in crisis, really, at the time. And her attorney, Roxanne Conlon, felt that the trial should proceed in a particular manner that would have taken, I don't know, 5-6 weeks to do if we had done it that way. There were pretrial motions that were presented in that particular case, motions in limine, and my ruling substantially limited the scope of the evidence that the plaintiffs were going to be able to present in that particular case, which shortened the trial considerably. At that point in time, Linda Chanin didn't think much of my ruling. And she had some real concerns about how this trial was going to go. But as the trial proceeded and all of the parties, each of the parties were given the opportunity to present their evidence and make their arguments, I think her fears were reduced, and the case resulted in a substantial verdict in her favor. So, you know, you have to manage a trial, manage the scarce resources of the judicial branch in a way that provides for efficiency, efficient dispute resolution. But I think you have to balance that with giving the parties a full opportunity to be heard. And the most important thing to me as a judge is that the parties leave the courtroom feeling like they got a fair trial. And I think even the defendants in that case probably would acknowledge that they got a fair trial. They had some issues on appeal, and the courts had a few minor criticisms of my decisions. But you know, these are highly complex, very difficult cases, and it's really hard in these types of cases to just get everything 100% right. That's why we have the appellate courts. That's what they're for. They're our safety net. And Mr. Brody, to address your question earlier, their ability to review the record and to collaboratively put their heads together and make sure that the trial was a fair trial and that the result was just and equitable for the parties is paramount. So Mr. Holm, in response to your question, that's what I want to do. That's why I'm here.
Your time's up, and I want to ask one question.
Okay.
Since you have been on judicial council probably the longest of anybody,
Yes.
I don't know if that's good or bad, but
Judge Sackett might disagree with that, but go ahead.
do you see anything changes that need to be done? I guess this commission was surprised that we even have judicial council. Well, they became aware of it yesterday, but is there any changes you think need to be done? So I know we get input from all the chief judges and the court administrators, and they come all around the state, and like you said, you bounce your mediation program at them before you go out there, but do you see any way we can change it to make it better? Well, we have to get the legislature to agree, of course, but.
Change the judicial council?
Yeah.
Well, the 21st Century report, the Futures Task Force that was done, I don't know how many years ago, maybe 10 years ago or so, recommended a council that was somewhat different in formation than the Judicial Council and had a broader spectrum of different stakeholders and judges and court employees and so forth, to either as a substitute for the Judicial Council or as an adjunct to the Judicial Council, provide input and recommendations to the Supreme Court. And I think that's worthy of another look. I would recommend, if we were going to do something like that, that it be not a substitute for the Judicial Council, but in addition to or an adjunct of the Judicial Council.
Yeah, I think Justice Lavarado even started that and made some appointments, but when the budget cuts came, it disappeared. Is that your understanding?
That is my understanding. The other recommendation that I would make is that the Supreme Court and the justices themselves meet at least annually, but regularly, with the Judicial Council in person, so that you can hear our recommendations personally and directly, rather than through the minutes of the meeting or through however they're being presented to you now, so that there's a better line of communication there. That would be one recommendation.
Yeah, I try to get down. I know other people do, but sometimes there's.
Well, I think if we could do it with some structure and formality, so that the meetings are set and we're all able to come, I think that would be helpful.
Thank you. Thank you very much, and we appreciate your time.
Thank you.
Thanks, Judge.